check. All rise, the President and the judges of the Caribbean Court of Justice.
Please take your seats. Caribbean Court of Justice, appellate jurisdiction, on appeal from the Court of Appeal of Guyana. Hearing of appeal in CCJ Criminal Appeal number 1 of 2019 between Linton Pompey and the Director of Public Prosecutions. Today's matter is being heard by the full bench, comprising their honors, Mr. Justice Saunders, President, Mr. Justice Witt, Mr. Justice Anderson, Madam Justice Rajnath Lee, Mr. Justice Barrow, Mr. Justice Burgess, and Mr. Justice Jamadar. Please state your appearances for the court.
May it please your honors. I appear in association with Mr. Ronald Daniels for the appellate.
May it please your honors. I, Shannon Ali Haq, the Director of Public Prosecutions, appear in association with Mrs. Tishana Lake, Assistant Director of Public Prosecutions, and Ms. Natasha Bakker, Assistant Director of Public Prosecutions. Your honors, permit me to wish the bench, full bench that we have here this morning, all the very best for the new year. Thank you.
Thank you.
Yes, thank you very much, DPP, and all the very best to you as well. Mr. Hughes, I gather that it is better for us if you sit while you make your submissions, and therefore you are permitted to do so while seated.
So, thank you very much, Your Honor. I just wish to echo the sentiments of my learned friend, Director of Public Prosecutions, and apologize for any distorted quality in the audio that you may receive.
Well, I can't resist saying that now that your country has come into a sizable bounty, that we hope it won't be too long before the infrastructure for information technology undergoes a very radical transformation.
I am happy Your Honor made that observation in the presence of my learned friend who is before you.
Yes, you can proceed, Mr. Hughes.
Thank you very much, Your Honor. I'm very keen not to be repetitious today, and as a consequence, unless I can be of help to the court, I would prefer to rely on the written submissions that we have laid over with the court. We elected not to file a response to my learned friend's submissions, essentially because I believe the issues which perhaps may be joined were fully expressed that we would seek to rely on our written submissions to you, unless, of course, Your Honors are desirous of further assistance from me.
Well, there are two issues here as far as I am concerned. The first is whether the sentences were appropriate. What's your succinct answer to that?
The individual sentences, counsel.
My respectful submission on that is that, Your Honor, that the individual sentence, each sentence, the 15 and 17 years, as well as the 5-year, were excessive, taking into account both the facts as established by the prosecution and the nature and manner in which the offense was committed.
Okay, so why do you say that the 17-year sentence was excessive?
I preface what I'm going to say by saying rape by itself and by definition, I concede, is an offense of considerable violence, whether attended by additional violence in the form of injury or not. So that's not the issue. We don't seek to advance that position. What I do urge for your consideration, however, is that the manner in which both offenses were committed appear from the facts to be offenses of opportunity rather than offenses in which there was some degree of planning undertaken by the convicted appellant. Additionally, number two, I believe that they were not, apart from the fact that, of course, there was no consent, they were not attended by circumstances of extreme violence, circumstances of extreme restraint, and circumstances in other similar offenses which strike at the conscience of the society. I also say that 17 years, given the trend of sentences, and this may be not necessarily the most relevant comparison, given the trend of sentences imposed for manslaughter and murder in which a life is actually lost, 17 years would be almost similar to those that are inflicted in those circumstances. And in some of the cases that we cited,
Mr. Hughes,
sorry.
We're talking about the 17-year sentence now. It has to be viewed against the backdrop that this was the third occasion on which he was committing a sexual assault against this particular person. And it also has to be seen against the backdrop that, as you say, it's a crime of opportunity. So, had he not been caught then, heaven knows how long he may have gone on preying on this young lady. So, in other words, I'm thinking that you are making too lightly of the circumstances.
No, I concede that the fact that he was convicted of these offenses, and I concede that the offense in and of itself is abhorrent. I also concede that this is the third time, and were it not for the discovery, there is a likelihood that if the opportunity presented itself again, he might have repeated that, subject, of course, to the young lady becoming an adult and consenting voluntarily. But that's not the issue. Your Honor, the 17 years, I'm not treating it lightly. What I would perhaps urge for your consideration is comparatively, in the absence of any particular guidelines, this compared to other offenses where there have been similar convictions appears above the norm, but it certainly would not be described as excessive to the extent that it is abnormal.
Mr. Hughes,
I will concede that part of it.
Mr. Hughes,
Sure.
maybe we should concentrate on this kind of offenses instead of looking around and compare it with very different kind of offenses, although I understand why you do that. But normally when a sentence is decided for a certain particular kind of criminal offense, there is usually what we call a starting point, and then you look at aggravating and mitigating factors to come to some reasonable number, so to speak. Now, you are an experienced criminal lawyer, so you must have an idea of that starting point. As I understand it, and maybe you can start with that. As I understand it, the trial judge in this case did not give any reason, or is it that she gave reasons orally, but they were not recorded?
I cannot speak to whether she gave reasons orally. I didn't have the privilege of conducting the trial first instance.
Okay.
So I'm relying merely on the record.
Okay.
I will concede, sorry.
So then, let's go to the idea of a starting point. Do you see something like that in Guyana for this kind of offenses?
Is your honest question, and forgive me for not understanding you clearly, is your honest question whether there is a general sense of a starting point in sentencing in Guyana for offenses of this nature?
Yeah, that's the question. Is there something like that in Guyana as far as you can see? Or is there a wide difference between sentences, or is it, to get an idea whether this is excessive, as you say, you start comparing with similar cases and to see if there is some deviation which cannot be understood.
Your Honor, my response to that would be patterns in Guyana would perhaps disclose a lack of clear consistency across the bench, but I would certainly say that 15 to 17 years would perhaps not be extraordinary in the circumstances.
Perhaps not extraordinary.
And is that your starting point, Mr. Hughes, or your end?
15 years would typically be somewhere in between, I believe. The sexual offenses court, unfortunately, has not been, quite often it depends on the bench that you get. But I would say 15 years would be somewhere in the middle, not necessarily the starting point, but somewhere in the middle.
Just to tack onto that, I wondered whether we could explore the feasibility of looking at a starting point, first of all, in the way Justice Smith described it, what is a starting point in Guyana? But I wanted to get your views as to whether it's at all feasible to look at the concept of a starting point in the region, a regional starting point. Now, of course, we have different societies composed of different combinations, but one of the things that is similar is the criminal legislation and legislation providing for punishment for some of these offenses. And often you find that the range of sentences is the same amongst different jurisdictions. I'm just wondering whether you think there is any feasibility in looking at a regional starting point, one, and in the event that you did not think that that is feasible, would you still nonetheless give some credence to what has happened in other jurisdictions in the region that face, for the most part, similar problems, so that we could perhaps get some guidance on what has happened in these other jurisdictions?
Thank you, Your Honor. Perhaps I would like to start with the invitation that was issued to the court in relation to sexual offenses by the heads of various judiciaries in the region, which resulted in the Juris Project, which set out some guidelines which I've included in my submissions. And subsequent to that, I believe the OECS, which seems to lead us in the rest of the Caribbean, composed a compendium of sentencing guidelines for the Eastern Caribbean Supreme Court that set out, I think, pretty comprehensive guidelines that I would urge be adopted in Guyana. So regionally, I think both the results of the Juris Project as well as the compendium of sentencing guidelines that the Eastern Caribbean Supreme Court has produced would be useful guides in Guyana. I, of course, forgot to say that I don't think it would be difficult for those to be adopted.
So in relation to your research then of what has occurred in other jurisdictions in the region, can you help us with what might be regarded as a starting point in those other jurisdictions for offenses of this nature?
Yes, please, Your Honor. I think Trinidad and Tobago for research, their starting point was 8-10 years. In terms of the Eastern Caribbean.
Now, sorry, I presume you are painting with a rather broad brush because you say 8 to 10 years, but of course there are different categories of offenses that we're concerned about. Incest perhaps is different from carnal knowledge, perhaps is different from, and so on. So you are painting with a rather broad brush, and you intend to do that, do you? Okay.
No, I'm sorry. I was specifically referring to rape in this case. I think our local legislation does not say that the convicted appellant was in a position of trust, because the position of trust is defined in the Act. I think it's Section 19. So I was specifically talking about rape.
Okay.
Of course, there is a familiar proximity between the victim and the convicted appellant. But I would concede that 15 years would not be excessive as a starting point in either the OECS or in Trinidad in some instances.
I believe Mr. Hughes that Trinidad and Tobago has also published and updated a sentencing handbook. I believe the updated version is 2016.
I thank you, Your Honor, and please forgive my embarrassment. I did not come across that, so please forgive me. I'm unaware that they did, so I apologize.
I'm looking at a case decided in, when was it? 2001 by a former president of this court, so Dennis Barron, and he dealt with 3 cases, some of which are not necessarily in violent dissimilarity with our case. And he indicated a number of guidelines, which I would suggest at some point you might wish to familiarize yourself with if you're not yet familiar with them. But essentially, he has for rape 8 years should be taken as the starting point in a contested case, and so on. There are some other guidelines he has here, but I'm just trying to figure out with your assistance whether there is any utility at all in our trying to fashion a regional starting point given the similarities of jurisdictions. Or is it a much more loose arrangement where we simply have reference to individual countries' guidelines, the jurist project guidelines?
No, I certainly believe that there is considerable merit in having a unified regional approach. I certainly do not believe that the socioeconomic circumstances throughout the English-speaking Caribbean and members of CARICOM vary that much to justify a separate and different regime for Guyana. I certainly do not think so. And certainly from the research that has been conducted by those groups that have done considerable work in this area, I'm unaware of any factors that would cause Guyana to be separate and distinct in the treatment of offenders who have been convicted of this offense. So I believe that there is considerable merit in a unified approach.
Yes, and it's interesting to place that against the backdrop of the CSME, of course, and in particular the freedom of movement enjoyed by our nationals. So that's just something to consider. Thank you.
Thank you.
Yeah, Mr. Hughes,
certainly could see that.
Mr. Hughes, it's also true that 2001 was a different time than now. Opinions about these kind of offenses have changed quite a lot. As far as you know, let's say the sentences that you would see now in Guyana, would those be the sentences you would see 30 years ago? Or has there been some development as far as you can tell us?
Your Honor, is this a general question on sentencing or one specific to sentencing and rape? Because, like,
I'm talking about sentencing of sexual offenses.
Sexual offenses.
Sexuality is one of those things that can be looked at, and offenses in that area can be looked at very differently from place to place, from time to time. So my question is there some more severe approach to this now, or then compared to 30 years ago, or less, or is it still the same? If you can say something about it.
Certainly, I certainly think that the sentences, perhaps I can, if I'm permitted to drill down a bit, sentences of sexual violence which have arisen in circumstances of home invasions and other kidnappings, perhaps attract a similar treatment from the court today. However, in relation to other types of sentences, I think certainly in terms of the social agenda of governance in general, sexual offenses has attracted a lot more attention today. There's been a lot more research done, so I think there's a lot more data. What I perhaps cannot say with accuracy is whether the information that has been collected recently because of the efforts appears to have indicated some increase, or because previously a lot of data was not captured, particularly from outlying communities. But in relation to sentencing, regrettably, and I say this with the greatest deference to those that occupy the lower benches in the High Court, there's a significant degree of variation subject to the bench that has conduct of a particular case. But the general view, perhaps, is that, if I could say, maybe 3 years ago, when a lot of the prosecution of these cases commenced, there was a tendency for harshest sentences. Now, certainly in the last year, I certainly believe that those sentences have been significantly reduced comparatively to what obtained 3 years before.
I see. Now, the maximum penalty in this case is life imprisonment, correct?
For the two of the three offenses, yes.
Yes.
Life, yeah.
Life. Then the question is, what does life mean in Guyana, in practical terms? Is that something you could give us some clarity?
Sure. Practical terms in Guyana, life is 20 years.
20 years?
Yes, and a prison year in Guyana is 9 months. What I will say, however, as a result of litigation, some of which I was involved in over the last 3 years, persons who were in death row and commuted to life, even though they were in prison for in excess of 20 years, have not been released. But those might well be special cases because those were persons who were in death row, and we had argued successfully that the President Morgan and the consequences of that, and they were commuted to life, but even though all of them, or most of them, are over 20 years, they have not been released. Generally, persons who have been sentenced to life, 20 years is the period.
Could you say, Mr. Hughes, from your experience, has in the last few years, Has anyone been sentenced to life? And if so, in what circumstances? What would be the nature of that offense? And has anyone, as far as you know, been sentenced to a period over 20 years? For this type of offense I'm speaking about, not generally.
For this type of offense, the present circumstances accepted, I think I'm aware of only one case where a person has been sentenced in excess of 20 years.
In excess of what?
20.
20 years.
20.
And that would be what type of case? Do you recall, or the name, or any reference point that we might be able to use? What sort of violence?
It was Justice Ramla. I'm embarrassed. I can't remember the case because I apologize. I can't remember the case, but I certainly can endeavor and ask my colleague to my left to try and get that before Your Honor's rise.
Okay. By the way, when the person is sentenced to life and released, let us say, after 20 years, do they remain on license for the rest of their lives, or is that the sentence served?
That generally tends to be the sentence served. I don't think there are many persons who are unlicensed. That regime, regrettably, in some circumstances, I'm not thinking in the case of rape, tends not to be deployed in Guyana.
Okay.
I think that's the result of, sorry.
I gather that you were naturally complaining about the consecutive nature of the sentence as well.
Mm-hmm.
I am indeed, Your Honor.
Is there anything you wish to say on that, very succinctly?
Very succinctly, Your Honor, on that, if a court were persuaded, and this is in the context, of course, both of the absence of any indication either from the court in first instance or the appellate court as to why the sentence was acceptable. However, in relation to consecutive sentences, I will say that the cumulative total of consecutive sentences, I think, is subject to the whole discussion about totality. And in this case, we end up with a 37-year sentence, where perhaps if one were applying the general principles, both those recommended by the court as well as in the OECS, it perhaps might have been preferable to impose a sentence of 17. I'm not saying I agree with that figure at all, and the other one to run consecutively. But on the totality principle here, Your Honor, we end up with 37 years, which in all practical reality is perhaps almost twice, forgive me for the comparison, twice the length of time someone convicted of manslaughter or sentenced to life would serve. Not even convicted of manslaughter, sentenced to life would serve. So on the totality, I think the manifest excessiveness of the sentence, if consecutive sentences were considered appropriate, that sum is considerably excessive.
Now, in relation to the totality principle, you, I think, referenced, is it Blackstone?
I did reference Blackstone, indeed.
Criminal practice. Was there any other source of authority you had for this totality principle?
Other than the guidelines, generally, the ones that I referred to before, both the OECS guidelines and the ones that the court has adopted.
Okay.
And the Jamaican court guidelines as well.
Okay.
Sorry. My apologies, Your Honor. After you.
I was just wondering in relation to all of this, the sentencing and so on. As you know, there are certain objectives, penological objectives served by sentencing. Punishment, deterrence, rehabilitation. Is any one of those objectives more privileged in your view in a case like this? Should we place particular emphasis on deterrence or rehabilitation or punishment in a case like this?
In a case like this, rehabilitation, I think perhaps is the one that appears to be most applicable. Deterrence, I'm not sure in these circumstances. There was no evidence that this gentleman, other than preying on this very unfortunate young lady, was so predisposed. So deterrence, I'm not sure in these circumstances, either individually or generally to the society, would necessarily have been the predominant consideration. I certainly think the assistance that a person like this would require would probably be rehabilitative.
So you're saying that rehabilitation would be the primary objective here?
Well, it ought to be the primary objective.
Oh, I see.
And is there a lot of rehabilitation going on in Guyanese prisons, Mr. Hughes? I visited one, and I didn't get the impression, but...
The Guyana Prison Service is under very acute and difficult circumstances because there was a fire maybe a year or 2 years ago that burnt down the main prison, which resulted in the inmates from that institution being rehoused in other institutions which did not have the capacity to accommodate them. And this has caused significant disruption to their existing inadequate capacities for dealing with particular inmates. So I think their circumstances are particularly acute at the moment, and therefore the short answer to your question is whatever capacity there was before, I think perhaps is considerably absent at the moment.
Yeah. So, in practical terms, punishing people in Guyana is more about paying the price, isn't that?
Yes, unfortunately, yes, it is, I'm afraid.
And so the question is then, what is a fair price, so to speak? Is there any line in, because as we know, if there are several offenses, the sentences have to be given to each offense, and then they can run concurrently or consecutively. Is there any line in Guyanese jurisprudence which tells you in such and such a case there will be concurrent sentences, and in such and such a case there will be consecutive? Is there a line, a clear factor?
I'm afraid as a national embarrassed, no, there's no. Well, my research has not disclosed such a line. Even going back to the lower courts of British Guyana, sentencing seems not to have attracted the attention of their honors at the appellate level.
Yes. Well, it's a problem in all common law countries. This idea of concurrent or consecutive is something which has been ignored by most academics even. So it is a point which, of principle, I think, which need to be looked at very carefully. Okay, thank you.
Mr. Hughes.
I just wish to. Sorry.
No, you go ahead, please.
No, I was merely going to comment that, and it's not been for the want of urging from the bar to the bench of the appellate level.
Yes, Mr. Hughes, I wanted to ask a little bit about the victim impact statement, which the guidelines that you reference, the sexual offences model guidelines, I believe, they deal with the whole issue of the importance of a victim impact statement, and of course some sort of report on the accused man or the defendant. I see that none of this was done in this case. Is that so? And can you let us know what has been happening in Guyana now? Because as I understand it, Section 61 of your Sexual Offences Act makes provision for a victim, well, what we refer to as a victim impact statement. But if you could just let us know what is the position now in Guyana and how is this important to criminal justice in Guyana?
I have to confess that our practices here are very rudimentary. Victim impact statements are non-existent, remarkable in their absence. What the most you will get in a case like this, or in a case of conviction, is a social report on which in which the investigator would report on the an interview with the victim. And this would not be an investigator that is particularly specialized in a victim impact, for example, the effects of victim impact, but it would be a report on more of a social report on the accused. And all of the times, the report is requested by a convicted person in the hope that it is used for mitigation. So the purpose of getting the report is not focused so much on victim impact, and it's more focused on an attempt to have the court perhaps consider in favorable circumstances the position of the convicted defendant with a view to perhaps a deviation downwards of any potential sentence. But there are no victim impact statements, and I'm afraid in our criminal justice system, again with considerable embarrassment, our practices are a bit rudimentary.
I see. I look forward to hearing from the DPP on this matter.
Yes, is there anything further you'd like to urge on this?
No, and I thank you. No, I thank you for the indulgence. There's nothing else I would urge for your consideration over and above my written submissions.
Yes, okay. Thank you very much. Madam DPP, would you please come to the podium?
Thank you, Your Honors. May it please Your Honors, as the President has rightly identified, there are two main issues that arise in this appeal. This appeal is an appeal from indictment in relation to 3 counts of sexual offenses, in relation to 2 charges, in relation to two offenses. The 2 offenses are rape of a child under 16 years and sexual activity with a child under 16 years. In May 2011, the appellant fondled the survivor, the complainant. She was the niece of his wife. He lived downstairs with his wife, and she used to visit the grandmother who lived upstairs. 6 months thereafter, he raped her. And that brings us to the first count of rape of a child under 16 years. And then 2 months after that, the next month after the sexual activity, he raped her. And then 7 months after the first count of rape, he raped her again. And on that occasion, that rape was witnessed. This is rare in rapes.
So just to be clear, the 3 offenses took place over 8-9 months?
Between May 2011 and January 2012.
So
May 2011 was the sexual activity, that was the fondling. The next month, June 2011, there was the first count of rape. And then 7 months thereafter, in January 2012, there was a second count of rape.
Understood. So
When he was caught,
I'm just trying to get a feel for the period of time. So it feels like about 7-8 months.
8 months, please, Your Honor.
Okay.
Your Honor, he was caught red-handed, and it was reported in the family. There was a family meeting, as we see from the record. It affected the family dynamics. The family was involved, and then it was reported to the police, and the charges were instituted. My respectful submission is...
Just a minute. What year was he charged?
He was charged in the same 2012, and the conviction in the High Court was in the year 2015.
And he pleaded not guilty to all three charges?
All three counts, please, Your Honor.
Was he on remand?
Pardon me?
Was he on remand when he was tried? When he was tried, was he in custody or was
No, he was always on bail, Your Honor.
he always on bail?
Always on bail,
From the very start?
from the start.
Okay, so after he was convicted, he was then taken to jail?
Yes, please, Your Honor.
Yes, okay. So since...
At his conviction, he would have been sentenced and remanded.
Okay.
And he was
So they
convicted in
sorry.
what year? He was convicted in what year?
In 2015. So we have no mitigating circumstance of him pleading guilty. We have no mitigating circumstance of him being in custody pending from the time of the charge to pending the conviction.
Is there any mitigating circumstance?
Your Honors, our respectful submission is that there are none. I tried to search hard.
Well, he had a
Was he
clean record.
convicted of anything before?
Your Honors, no, but he would have been convicted of 3 offenses. Fortunately for him, all 3 charges were instituted at the same time.
Why you say
The
that
first-
is fortunate for him?
Because had the first one been reported at the time when it happened, he could have been charged then, and he could have had a separate trial then. And then when the second one happened,
Would not have happened. He would be in jail.
It would not have happened, you would have been in jail. But putting aside that circumstance, I'm trying to wrap my head around the notion that this was good fortune on his part, that the matters were tried together. It seemed to me
because,
the
Your
opposite.
Honor, they are separate charges. The state always has the state can institute separate charges. They can have separate trials, and then but it would be a waste of time.
Yeah, but
And
that's nothing to him, that's to the state. It's good fortune for the state or for him that they were tried together.
Well, you can put it, I would put it both ways in that.
Let me ask you this question. If, putting aside the inconvenient circumstance that Justice Witt raised, that if he had been tried on the first one, had been caught and then been tried, he wouldn't have been in a position to commit the second and the third. Let's put aside that. But if he had been tried, let's say on the second one, and got 15 years, and then several months later, he comes up to be tried on the third one, you really believe that the judge would have said to him on the third one, well, you did this before, so I'm going to give you 17 years. But the 17 years will begin to run 20 years from today. You really believe the judge would have said that?
Your Honor, it depends on the circumstances, it depends on the judge, because as we are aware, different judges will take different approaches. And
You believe that there are judges in Guyana who would have said in these circumstances that if he had been tried separately on the third count, that they would have said to him, we give you 17 years, which will begin in 20 years' time? You've ever seen that?
no, please, Your Honor.
How long have you been practicing in the criminal courts?
I have been at the bar, this will be 30 years.
So you've never seen that in 30 years?
No, please, Your
So
Honor.
it is a great misfortune to him that they were tried together. Because if they had been tried separately, the likelihood is that on the third count, the third charge, the judge would not have said, which the judge said on this occasion when they were tried together, that he should commence his sentence after 20 years had expired. So it's not of great fortune to him. It's a very great misfortune, I would suggest.
Your Honor,
Counsel, could you add to what the President raised? The following proposition, which is, if there had been separate trials, on the last trial, what the judge would have done would have said, you have a prior conviction for this offense, and therefore the sentence that I'm now going to impose will be aggravated, will be increased by the fact of the previous conviction. Is that not the standard thing?
yes, please, Your Honor, we could have had that, and I will respectfully submit that particularly in the circumstances in Guyana now, there is a prevalence of sexual offenses. Every assizes, when I do a list, more than 55% of the cases on the lists are for sexual offenses. And more than 75% of those sexual offenses cases are for offenses committed on children. This offense concerned a child. For the January 2020 list, I have 346 cases listed in Demerara.
What year is that, sorry?
This year, this assizes, January 2020.
How many you said?
346 cases. 167 of those cases are for sexual offenses.
How many?
And-
Slowly, how many?
167. And out of the 167, 117 cases is for sexual offenses involving children.
117?
117.
Now, that's for this year.
And that has been the trend last year and within recent years.
Okay, and when was
That's for Demerara only.
when
and
was
there's-
this accused sentenced?
Pardon me?
When was this accused sentenced?
In 2015.
And he was given 37 years.
And he was given 37 years.
Okay, so notwithstanding being sentenced to 37 years in 2015, you still have some horrendous numbers. And I think we all agree that the offenses for which he has been convicted are horrific offenses. Nobody disputes that. That is not the issue. The issue is what is the proper punishment for those offenses. Now, to have given him 37 years in 2015 seems not to have had the kind of effect on the numbers, because you're saying this year you have 346 cases, sexual offenses, 167 sexual offenses, and then 117 related to children. So, you know, one definition of insanity is doing the same thing over and over again and expecting a different result. Nobody's saying that Mr. What's his name?
Pompey.
Mr. Pompey should not be recognized for doing the very evil thing that he did. Nobody's saying that. Nobody's saying that he ought not to be punished. The question is, what is the extent of the punishment? And does it make sense in the context in which we're talking about? Certainly, it would not have had, going back to the penological objectives, the deterrent effect that you'd have thought giving 37 years would have had, because otherwise you would not have had these numbers.
Your Honors, although we have that large number, there has been a lot of work being done within the judiciary to clear the backlog. So some of those cases will not be necessarily from 2015 to now. Some of them may be from before. Hence, the present sentence would not have had an impact on those offenders. There would have been offenders that committed offenses prior to the time of sentencing.
I accept that, yes. Yes,
So
I
in
accept
these
that.
circumstances, issue there would be whether the 5 years for the sexual activity is not excessive. And my respectful submission is that it is not. because given the circumstances and
No, but sorry, that's another broad brush term. When you say the circumstances, in response to my sister's question, apparently there was no, what is it called, pre-sentencing report done.
the victim impact statement.
Yes.
Actually, Your Honor, that is something that our Sexual Offences Act was in 2010. It's a fairly new act. And as Justice Rajnath is aware, because the same time she came to Guyana, Her Honor came to Guyana to launch the guidelines for the Juris Project in sexual offences cases. That same time, we launched in 2017, the Sexual Offences Court. And from then, because there were so many cases, Chancellor decided that there would be a Sexual Offences Court. It was launched in 2017, and since then we have been disposing of more cases. The court has been more focused, and there has been more attention being given to these offences because of their very nature.
Yes.
The circumstances in this particular case, Your Honor.
And rightly so, obviously. But could I ask you a question I'd asked of Mr. Hughes earlier? In relation to this kind of sentence, what predominantly is the objective that is sought? What is the penological objective that is sought?
Your Honor, as Your Honor rightly said in the Anderson case, from this very court,
yes.
You have rehabilitation, the public interest.
Yes.
You have deterrence, you have rehabilitation.
Yes.
You're hoping that it will be a deterrent to the offender himself and to potential offenders.
Yes.
And we see the importance of that in this offense because the offender himself kept reoffending. And within recent times, we have been using the victim impact statement. Within the last year, it has been used in sexual offense cases.
I think that obviously that has to be very important, no question about that.
Yes.
But it wasn't used in this case. So coming back to this case for the moment, do you think that punishment of this reprehensible behavior warrants incarceration for 37 years?
Your Honor, given the circumstances, and I would like to go into the circumstances, please.
Sure.
He started by fondling her. He did this thing in a family environment. He did it in the sanctity of her grandmother's home. And then he moved. He was an adult. He was 43 years of age. She's a child, 14 years of age. And then he moved the next month to raping her.
Yes.
And again in the grandmother's home.
Did he use,
and he continued to do that.
Did he use violence beyond that which is necessarily implied in a sexual offense of this nature? Did he use a knife or?
It's a sexual predator, I would respectfully submit. And they know how to deal with children. They know how to get that child to do what they want that child to do.
But I gather the response to my question is no. And if he did not do that,
the act of rape itself is an offense of violence.
Absolutely, I've conceded that point. What I'm asking you is, well, I'm saying because I don't think you're objecting, that he did not use any violence beyond that which is necessarily implied in an offense of rape. Would you concede that?
Your Honor, in cases of rape, there's something called consent and there's something called submission. And that's why from way back in the common law, we had consent and we had submission. And I would respectfully apply that here. In that, consent is not an issue here. No. But just as how in rape, there's consent and there's submission, in a case like this, he may not have used excessive violence because of the circumstances and his predatory
yes.
It was unnecessary
disposition.
to achieve the objective.
It was unnecessary to achieve the objective.
I got you.
But
Thank you, Your Honors.
Let me find out from you. You have a difficulty with the, see, it's someone who said that he got 37 years. I don't subscribe to that view. I think he got 17 years. Do you have a difficulty with the 17 years that he got?
For the second
For
rape.
the second rape.
No, please, Your Honor. Your Honor, and my reason for that is that has been a trend in Guyana. When you go back to Lennox Thomas's case by Chancellor George, and that was so many years ago, Chancellor George gave Lennox Thomas, he was given 20 years, and Chancellor George did not reduce it. And you had a similar case even in Trinidad here of Edwin, and the accused was given 20 years with hard labor. Our starting point I would look at following Aguilera, which was adopted by this honorable court in TRAT. I think 25 years is a good starting point. When you take into consideration...
Counsel,
25.
starting point?
Yes, please, Your Honor.
With respect, a starting point has to be what in an ordinary case, not excessively heinous and not excessively mild, the starting point is where you start from.
We could start with 25 years because of the circumstances here. This is a 43-year-old adult, please, Your Honor, with a 14-year-old child.
Start at 25 years, and then you add in the aggravating factors. Where will it take you?
You could have gotten 2 to 37 years.
For one offense? I'm just asking you for one offense. This is the point.
It would depend on the circumstances of each case. Every case has to be tried on its own facts.
Let me a question which has been engaging me. If there had been separate trials, and there was the separate trial for the later rape, is it not the fact that the aggravation for having earlier committed and been sentenced to an earlier rape an earlier rape conviction, that the maximum sentence which could have been imposed in the case of the second trial for rape would have been life imprisonment?
Yes, please, Your Honor.
And that we know would be essentially 20 years.
Not necessarily, Your Honor.
I didn't say necessarily. I said it would be essentially 20 years.
Your Honor, I had a discussion with the Director of Prisons because I've been hearing this thing during my years at the bar, that life imprisonment is 10 years, life imprisonment is 20 years. I asked the Director of Prisons. He said life imprisonment is life imprisonment. And that's why, if you notice recently, the judges have been saying you're sentenced to life imprisonment for rape as well as manslaughter and even murder, because some of the accused have been found guilty of murder and sentenced to life imprisonment. It's life imprisonment with no possibility of parole after 20 years, before 20 years, before 25 years. And we have had offense sentences of 30 years and 35 years for rape of children. The court must speak out. It must protect society.
Are you saying that in Guyana there are precedents where for the rape of children, sentences have been imposed of 30 and 35 years?
Yes, please, Your Honor.
You have brought those to our attention. Have you brought those cases to our attention?
No, please, Your Honor. I didn't put it in the submissions.
Because on the ordinary methodology, if you use the Aguilera formula, you look at the maximum penalty, you look at the nature of the offense, you take into consideration the aggravating features inherent in the type of offense, in this case rape, and you try to come to a figure, then you can adjust that up or down for aggravating or mitigating factors relevant to the offender, correct?
Yes, please.
Part of the task is for certainty in the law, and therefore to find what is the range, the appropriate range, right? Goes back to starting point, right?
Yes, please.
And to get that appropriate range, you need to have an idea of what prevails in the region. Sentences that have been imposed, right? To find a range. Yes? how
Yes,
are we
please,
going to
Your
find
Honor.
it right? So how do you expect us to discover a range if you don't help us with the authorities that say what are the kinds of sentences that have been imposed for similar offenses in Guyana?
Your Honors, respectfully, I did quote the case of Lennox Thomas,
Lennox
where
Thomas is 17 and 18 years. Sorry, 15 and 18, is that all right?
Lennox Thomas is 20 years, please, Your Honor. 20 years, and Your Honor, that
You were
case
I know,
was
but
way,
you- but you
was
were
some
telling-
years ago.
Yeah, but you were telling us of 30 and 35 from the bar table.
We have had it. We have had 30 years, you have 25 years, you have 20 years, we have 18
I know,
years.
But what, yeah, why?
But DPP, what I am asking is, the authority you send us of Lennox Phillip is for 20. Did
Yes.
you send us any authority in which a sentence over 20 years was imposed in Guyana?
Your Honor, the Lennox Thomas case is a Court of Appeal decision, and these sentences
Doesn't matter.
are High Court decisions.
Does not matter. It shows what the local courts think appropriate for a certain type of offense. Anyway, you haven't done it. Are you in a position to help us with that? If
Yes,
not
please,
today,
Your, most
afterwards?
certainly, please, Your Honor.
Okay, let's move along.
Well, what do you propose to do then, Mrs. Ali Haq? Just tell us. Is it just those cases that have come in the last 3 years from the Sexual Offences Court, or are you going to go back to pre-Sexual Offences Court? Because I think, what would you want to do? Give us about, what, 6-8 years a range?
Your Honor, the Sexual Offences Court was in 2017, October. I can definitely give this the 6 for those courts, and I can even go back and I can give, because 2017, 18, 19, that would only be 3 years. I can give you the last 5 years, and I can even give you more. What was happening is we have a big backlog in Guyana in the High Court, and a lot of persons are charged with murder. They are on remand, they are in prison, and we had been given those cases priority because the persons are in prison until Chancellor realized that these cases were being neglected to some extent. And then we had the Sexual Offences Court in 2017, and since then that court has been focusing on the sexual offences cases strictly. So you'll get more statistics and you will get a wider range of the sentences.
Remember, we want similar circumstances.
Yes,
Remember-
but with
remember-
children.
Children, yes.
But
Yes.
not only children, but you have a certain factual matrix. So it is helpful to have similar circumstances with this matrix, but there may also be some instances where there are additional features of, let's say, violence. I take completely what you describe about this type of offense in relation to minors. And I think that, for myself, the idea of a sexual predator is something that the courts need to recognize as a particular category, not just talk about a rape. You suggest that this case has those features because of the fondling first, and then the first rape, and then the second rape, and but for the discovery, which you say is
Yes.
unique, that this could have continued for however long. So that in what you give us, you need to put it in categories that can be helpful, okay?
Your Honours, I have at present 7 cases with the names and the sentences. Would you like to have them?
Oh, we certainly would like to have them.
More.
For myself, and please make them available. You have not cross-appealed against the longest of the sentences. You have not cross-appealed against any of the sentences. So that the sentences on the respective offenses are still 5, 15, and 17. And this court could either maintain that or vary them downwards. So presenting me with cases that show that for a rape, a person got 19 years or 20 years, to me is not particularly relevant. What is really relevant, as far as I'm concerned, is for you to tell me what are the principles that condition whether sentences that are resulting from counts on a single indictment should be made to run consecutively or concurrently. To me, that is really the most salient issue that you need to convince me on. Because these other issues of whether you should have gotten 7 years instead of 5, and in fact you said to me that you didn't have a problem with the 17 years.
No, please, yes, please, Your Honor. I don't have an issue with the 17 years, the 15 years, and the 5 years. But I was asked a question by His Honor, Justice Barrow, in relation to general starting point in all cases. Your Honors, I don't have a problem with the 17, the 15, and the 5 years. I think that they are adequate. And in relation to the consecutive sentences, which is your concern, and
before you go there, you see, what I have a difficulty with is in the prosecution taking a view that, you know, he should have gotten a lot more than 17, but he only got 17. So let's make them all consecutive so that in effect he will get 37. To me, that is not a proper approach. That is not a principled approach to the issue of whether these sentences should run consecutively or concurrently. There are principles that govern whether sentences should run consecutively or concurrently. And I would really like to hear whether in this particular case, the application of those principles was such that the application warranted these sentences to run consecutively.
consecutively. And the issue there would be the totality principle. And I'd like to refer Your Honors to my reference to Blackstone's Criminal Practice Supplement 3, which outlines circumstances under which consecutive sentences can be granted to the appellant when it is the same victim, because I think that's what we are concerned here with. These are where the offenses of domestic violence or sexual offenses are committed against the same individual, as we have in this case, Your Honor. The 3 offenses were committed against the same child over a period of time of 8 months. A child is a vulnerable person. These offenses, by their very nature, were violent offenses. And then further in...
But you see, I don't know if it's I alone. I'm having this conceptual difficulty. The judge didn't give him 15 years on the second rape. The judge gave him 17.
17 years, because it was a repeated offense.
Exactly. So that already there was taken into account some aspect, some notion of the same matters that underline the totality principle. In other words, the judge would have considered, look, you would have done this thing before, and therefore I'm going to up the sentence. Now, if in addition to that, you make it consecutive, then it seems to me that you are inappropriately doing a second time what you did the first time. That is, you are counting twice the aggravating factor that this was a subsequent occasion that he was doing this to the same victim. Do you understand what I'm saying?
But then, Your Honor, he had done it twice.
That's why he got 17 years and not 15. First time he got 15.
Yes, please.
So then, what's the basis upon which you then add up all together and say, well, we'll make them run consecutively?
Because they were with the same victim, and it was in the sanctity of the home. The child was vulnerable. He had betrayed that position.
Those are all factors which the trial judge must have considered
In the first.
and given 17.
Right, in given the 15. And then the trial judge looks back now, because it's these same circumstances, he does it again.
And the trial judge gives him 17.
17 now.
So, having factored all those circumstances, is it appropriate to factor them yet again by adding up all the sentences?
Your Honors, I'd like to refer you to the cases of Hardy and Whitley that I've referred to in my submissions. In Hardy, you had the appellant committing 3 different traffic offenses. And Mr. Justice Hilbury, in that case, he said, if I didn't give an additional sentence and make it consecutive, it would have been bizarre, because then this appellant would not have been adequately punished. That goes back to the principle of the punishment, public interest, deterrence. And then we had Whitley. And
So
in
you're saying
Whitley,
that just a minute, you're saying adequate punishment in this case was 37 years.
yes, please, Your Honor, because there were 3 different occasions, and his complacency, his predatory behavior in the sanctity of the grandmother's home, he took advantage of this child. And this is happening to too many children in the Guyanese society.
Okay, suppose this was one that was accompanied, because in order for him to achieve his objective, it needed to be accompanied by violence. Suppose he had a knife to her throat. Suppose he had ripped her clothing. Suppose he had damaged her private parts. What do you think would have been reasonable?
The maximum is life imprisonment. He could have gotten life imprisonment. He could have gotten 20 years.
But if he had gotten life imprisonment, he could not get the other sentences consecutive to life. Isn't that the point? Having gotten life, he could not add on to life 15 years, could he?
Yes, please, Your Honor.
So that's the point.
So that's why the judge would have given the years,
Right.
because he gets to go in there,
So if life was
and
not
hopefully he
appropriate,
will reflect and rehabilitate.
life is not appropriate if the maximum penalty is not appropriate for the second rape, then is it proper to nonetheless add on to the less than maximum, almost double the term, so as to get it past what a life imprisonment would in practice have meant?
Your Honor, I'd like to put it a different way. I'd like to put it that even though he committed 2 counts of an offense that carries a maximum of life imprisonment, and I agree that if he was given the maximum, they would have had to be concurrent, because you can't have 2 life imprisonments consecutively.
The Americans have done it, but go ahead.
I appreciate that point, Your Honor.
I'm being facetious.
But I appreciate the point that you can't have 2 life imprisonments. But please, Your Honor, and you don't have 2 life imprisonments here. We have a 15 years and we have a 17 years.
So if he had committed this 3 more times, would that get us above the 100 years? I mean, how do you deal with that? You could say, well, you pay the price for one, the second one is a higher price, the third one is an even higher price, and we count everything. it leads to some form of absurdity. How many times you have to do this to get to life? And then what is life? Life is, in practical terms, 20 years. These 37 years is more, okay. There might probably be a 1/3 remission,
Yes, please.
but it will still take you above the 20 years. It is, there are so many circumstances that could make it more aggravating than this. Nobody disputes that this is very bad. But coming back to what Justice Anderson was saying about, okay, what are we trying to achieve here? We want to express how bad this is. Okay, 10 years does not express that it is very bad, or 15 years. But then you could also say, no, we want to keep this man out of society as long as we can, so he can't do it again. Is there any reason to even suspect that he would do it again? I don't think we have any material there. Does it make a difference? For example, yes, he did it twice, at least the rape. Does it make a difference that he did this while he was undetected, or if he had done it the first time and he would have gotten 15 years, he would have spent his time in jail, got free, and did it again? That's a very different situation, I would think, because now you have felt what it means, you have undergone the sentence, and still you do it again. That makes it very different from doing it twice without having been punished, I would think. So there are so many factors here to consider. And once more, there's nobody here or elsewhere that doesn't say that this is bad behavior, very bad behavior, and that we have to do something, if we can, to protect victims, children. That is absolutely true. But unfortunately, sentencing needs to have some rational basis. So we don't go into the emotions too much. What is rational here? And that is what we're trying to find out with you.
Your Honor, there's two comments I'd like to make in relation to that. The first one is the sentence. Let's look at it from the perspective of the totality principle and the 37 years. Because I think that's the concern of the court, and I can see the concern of the court. This man will be in prison for 37 years. But a prison year is 8 months. And they're entitled to parole if they are of good behavior. So even though he may have gotten a sentence for 37 years, he will not spend 37 years in prison. That's my first point. And the second point is we need to look at the offenses and, to borrow your word, Your Honor, and rationally look at it. This is an offense involving a child and an adult family member in the sanctity of the home, the predatory behavior. I would respectfully submit, when we go back to the previous CCJ decision in relation to indecent assault, 5 years, so that 5 years that he got for the sexual activity, we don't call it indecent assault, we call it sexual activity with a child under 16. And it's always a child under 16 because the Act defines a child as a person under 18 years. The maximum for that sentence, for that offense, is 10 years. He got half of that, he got 5 years. And that's consistent with the CCJ decision. For the second offense, which is a rape of a child under 16, that carries life imprisonment. And I agree, Your Honor, that you can't have 2 life imprisonments. It would make no sense. And consecutively. But he got 2 sentences, one of 15 years and one of 17 years. Obviously, the judge would have taken these factors into consideration in arriving at that 15 years for the first count because of the circumstances as I just outlined, and 17 years for his complacency now and the repeating of the offense. And in these circumstances, my respectful submission is that these sentences are not excessive given the circumstances. That's the individual sentences of 5, 15, and 17. And the next issue now will be the cumulative effect of them based on the totality principle. My respectful submission is that the 37 years, it's consistent with our sentencing pattern in Guyana, and that's from years, from since the 80s, because Lennox Thomas would have been in the 80s. And compared to then, sexual offenses have increased. As I always say, I don't know what's happening in the society. Children are being raped voluntarily and involuntarily. And it's sad, and as the Jewish guidelines said, the courts must provide some protection, send a message. And I think it's for this very reason that the Court of Appeal did not interfere with the sentences. And as they said, it's a serious offense and it should be dealt with condignly. And they would have taken a position based on the statistics that are existing in Guyana in relation to sexual offenses, and more so sexual offenses committed on children. And this is my respectful submission to this honorable court. And I refer also to the decision of this court in Vishnu Jalal and Hardat Hari Prashad, where this honorable court held that consecutive sentences may be given where the offenses arise out of unrelated facts or incidents. These were 3 separate incidents with facts from 3 different occasions: May 2011, June 2011, January 2012. Consecutive sentences may also be imposed where the offenses are of the same or similar kind as we have here, but where the overall criminality will not sufficiently be reflected by concurrent sentences. And that is supported by the Hardy case, where the Court of Appeal held in England consecutive sentences for dangerous driving, driving while disqualifying and failing to provide a specimen. It would be bizarre to add no further custodial term for the other matters. And similarly, in the other English case of Whitley, where Justice Hilbery said, in these circumstances, the practice of the court operating in many cases of passing 2 concurrent sentences for 2 offenses arising out of the same facts cannot apply. Otherwise, this man would have a license to drive with excessive alcohol without any added penalty. And this, I respectfully submit that if the learned trial judge had not given the additional 2 years, then it would be given a license, the court's given a license to sexual predators of children to continue to do this type of behavior. It would have been sending the wrong message to this offender as well as potential offenders.
Madam DPP, as you continue with that, could you just include in what you're telling us a little reference to what the Court of Appeal did? Because that is the only place where we see the reasoning of the courts in Guyana as to an offense of this nature and how sentencing should take place.
Your Honors, the Court of Appeal had said as regards to sentencing, it is complained that no reasons were given for the imposition of consecutive sentences. It is noted that the incidents are 3 separate incidents spread over a period of 8 to 9 months.
Is it normal in your experience that trial judges do not give reasons when they impose a sentence?
Your Honor, I think it was like the practice, but we are slowly improving on that. And, you know, it's so strange. I sent my submissions on the Thursday. The Friday was the deadline. And on that Friday, Justice Lucky was in Guyana, arranged by Chancellor and Chief Justice to deal with sentencing. So I am sure that the decisions coming out of Guyana from now on will have more, they'll be reasoning, and you will see reference being made more to Aguilera and Tirat, and you will have a different, the judgments will justify the sentencing that was the sentence that was passed. It is noted that the incidents are 3 separate incidents spread over a period of 8 to 9 months. This is not a case where the offenses charged flowed from one incident, in which case it would be expected that the sentences would be ordered to run concurrently. It is clear that the conduct of the appellant amounted to ongoing sexual interference with a child in relation to whom, as her uncle, he was in a position of some trust. We are not speaking in the technical sense of a position of trust as defined by Section 19 of the Sexual Offences Act, as referred to by my learned friend, Mr. Hughes, to ongoing sexual interference with a child in relation to whom, as her uncle, he was in a position of some trust. As he said in his statement, he knew her from when she was little. She was clearly a regular visitor to the home to assist with the care of her grandmother. She should not have been violated in the way that she was. In the circumstances...
I found that a very strange sentence. She should not have been violated the way she was.
That's what I thought.
I think that is a very unfortunate expression.
Page 280 of the record, please, Your Honor.
Yes, I know that it's there, but it is a very strange way.
It's a very
put things.
unfortunate expression.
Yes, yeah.
But anyway, go ahead.
Keep going, yeah.
In the circumstances, we do not consider that the trial judge was incorrect in imposing consecutive sentences. The incidents of rape, and particularly rape of child family members, are prevalent, and the courts must treat with these cases condignly and send a strong message as such would not be tolerated. Therefore, the conviction and sentences are affirmed and the appeal is dismissed.
Just for my benefit, thank you. Just for my benefit, can you advise me as to whether this gentleman, Mr. Pompey, has been charged with any other sexual offenses?
No, please, Your Honor.
He has not been.
No, please.
Okay. Whether in relation to family members or any, okay. And he was out basically on, he was awaiting trial.
Yes, please, Your
And he
Honor.
was out for how long? A couple of years?
3 years.
3 years,
Yes,
yeah.
please.
And during that time, he did not, in fact, bring himself to the notice of the law in this regard, right?
Yes, please.
Okay.
Your Honor, just before, I'd like to reiterate one of the submissions that I made in my written submissions, and I'd like to read from Mr. Justice Hilbury in the Queen against Blake. And this was...
Counsel, I had the utmost difficulty with seeing how you could look at this horrendous spy case. I don't know if you're an espionage reader as I am. Blake, Burgess, and Kilby. I mean, this which so polarized and traumatized England, treason violation of the Official Secrets Act. You are looking to make a comparison between the abhorrence of the entire nation of England as to what this man was doing to the nation, and you're comparing it with. However traumatic it was for the child.
And it was.
What is done for one individual, please.
Your Honor, the offense itself.
Yes, exactly. And
Offense itself of sexual act of rape of a child,
Yes.
rape of a child under 16, is abhorrent.
Of course it
Of
is.
course, very respectful.
Nobody's denying
And I
that.
thought that we could borrow from the wording of Mr. Justice Hilbury, because I liked how he worded it.
Well,
And it's applicable to the prevalence of sexual offenses of children in the Guyanese society. I am faced with these files on a daily basis.
Counsel, if you find, as it were, that there's some resonance in this entirely inapplicable case, but in the wording, then feel free. You will notice that I have read the case, etc.
I realize that, Your Honor.
If you want to say it again, say it again.
It is of the highest importance, perhaps particularly at the present time, that such conduct should not only stand condemned, but should not only be held by ordinary men and women in utter abhorrence, but should also receive, when brought to justice, the severest possible punishment. And I think this is what the learned trial judge would have been considering when she gave the sentences of 5 years, 15 years, and 17 years. And it's what the Court of Appeal, in taking the position of dealing condignly with this type of offenses, would have done. The sentence had a threefold purpose. And I remember Justice Anderson in the CCJ decision. It was intended to be punitive, it was designed and calculated to deter others, and it was meant to be a safeguard to the children of Guyana.
Thank you.
Were you at the trial of Mr. Pompey?
No, please, Your Honor. Ms. Bakker was at the Court of Appeal.
All right, that's the extent of your submission.
I respectfully ask this Honorable Court to find that the sentences given, the 5 years for the sexual activity with a child under 16, and the 2 sentences of 15 and 17 years for rape of a child under 16 years were not excessive, and that the order of the Honorable High Court Judge, which was affirmed by the Court of Appeal of Guyana, for them to be served consecutively, was not excessive. Please, Your Honors.
Thank you.
Yes, Mr. Hughes, is there anything you wish to say in response briefly?
No, Your Honor, simply to invite your attention to paragraphs 50 and 52. There are 2 cases that we refer to there that I think may be useful. That's the only comment I wish to make.
I'm sorry, I didn't get...
I'm sorry, I was saying save and accept to invite your Honor's attention again to paragraphs 50 and 52 of our written submissions, which refer to 2 cases. But that's just to invite your attention to it. Nothing other than that, Your Honor.
Thank you.
Can I ask you one more question? I was just wondering, he got bail at a very early stage and then had to wait another 3 years for the trial. So what happened? Did he return to his family, or did he never return to his family? Is there anything you can say about that?
So, Your Honor, is that addressed to me or to my friend?
If you can answer, please.
Yes, sorry, yes.
Yeah.
When he was put in bail after the charge was read to him, he continued to live exactly at the same address.
Okay.
So he returned to his family at the same location on the east coast of Guyana.
Okay.
Okay, thank you.
Okay, that's it.
That's it.
Okay. Thank you very much, Counsel. The court will reserve its decision in this matter.
All right.
You gotta tell that.